Good afternoon, everyone. For those of you who don't know me, I'm Jeannette Castagnetti. I'm a circuit court judge in the First Circuit here on Oahu. I've been a circuit court judge for 5 years. Prior to that, I was a per diem judge in district court while I was also in private practice. It's really a privilege and an honor to be here today to give you an update of the environmental courts in the circuit courts on all circuits for the state. Let me just go on to, I know we're a little behind schedule. I'm just going to cover these 4 areas. I'll go over just a brief overview of the environmental courts in circuit court, the jurisdictional statute, the types of proceedings that we see in circuit courts involving the environmental court matters. I'll talk also about the cases that have been filed since July 1, 2015, when environmental court first was established. And also I'm going to briefly mention some recent legislation that was passed this past session that does involve or impact environmental courts jurisdictional statute. So moving on then to the jurisdiction of the environmental courts, and I know most of you here already know this. The environmental courts shall have exclusive original jurisdiction over all proceedings, including judicial review of administrative proceedings and proceedings for declaratory judgment on the validity of agency rules authorized under Chapter 91, arising under Chapters 6D, 6E, 6K, etc. If you count all of the Hawaii Revised Statute chapters that are enumerated in the jurisdiction provision for environmental courts, there are 60 chapters from the Hawaii Revised Statutes that are included. Some of the types of chapters or laws that we'll see in circuit court and have seen involve historic preservation under Chapter 6E, air pollution control under Chapter 342B. I'll talk a little bit more about that later. There was an environmental court case on Maui that involved that chapter. Water pollution under Chapter 342D, safe drinking water, solid waste pollution, and Chapter 343, the Hawaii Environmental Policy Act, otherwise known as HEPA. Now, the types of proceedings that we see in circuit court, I know this is very general overview, but we do hear civil cases. Mostly those are cases that will involve claims for declaratory and injunctive relief involving the enumerated chapters set forth in 604A-2. We also hear criminal cases, jury trials, so misdemeanor jury demand cases for criminal offenses as well as felony offenses. And we also hear agency, what I'm calling agency proceedings. Those, of course, involve judicial review of contested cases before administrative agencies, so judicial review of final decisions and orders or certain preliminary rulings of a certain nature in contested cases under Section 91-14A. Also, declaratory judgment cases or declaratory judgment actions on agency rules concerning the validity of agency rules under HRS Section 91-7. So let's get to the stuff that I think you folks really want to hear about, and that's sort of the types of cases or the specific cases that have been filed since July 1, 2015. So the very first case that was filed in circuit court was on July 1st, 2015 in the Second Circuit. I think the plaintiffs were lying in wait, waiting for the opportunity to file their case. That case was called Stop Cane Burning versus Hawaii Department of Health and Alexander and Baldwin. It had been in the media. So some of you may have read about that case. I don't know if there are any lawyers who participate in that case who are here today. But again, that was in the Second Circuit. That was before Judge Cardoza. And let me just also say, too, that the cases that I'm talking about specifically some of them are still pending cases, and I'm not saying anything here today that's not already part of the public record. So let me just make sure everybody understands that. Now back to the Stop Cane Burning case versus Hawaii Department of Health. That case involved a number of claims, one of which included Chapter 342B involving air pollution control. As I'm sure you can imagine from the title of the case, you can get a sense of what the case was about. But in that case, what the plaintiffs did is they filed an action for declaratory and injunctive relief and claimed a number of things, but among them was that Chapter 342B of the Hawaii Revised Statutes violated the Hawaii Constitution, first as an unlawful delegation of legislative power, and also that the ongoing authorization of cane burning violated individuals' right to a clean and healthful environment under Article 12, Section 9 of the Hawaii Constitution. Now, the parties engaged in various motions that were heard by Judge Cardoza, and eventually the parties were able to reach a settlement agreement. And that settlement agreement included Alexander and Baldwin agreeing to stop cane burning by the end of or late December 2016. And on June 1st, 2016, there was a dismissal of the case by stipulation. That was on June 1st, 2016. So maybe about 11 months later was when the case was resolved. Now, as for the other circuits and the other proceedings that we've seen and types of cases that we've had, we do not have the volume that district court has. We are nowhere near the 1,600 cases that Judge Richardson talked about. Statewide, we've had 11 civil and agency-related cases filed in all circuits. So in the state of Hawaii, of course, you folks all know we have 4 circuits. First Circuit, Oahu; Second Circuit, Maui; Lanai and Molokai; Third Circuit being the island of Hawaii, or the Big Island; and then the Fifth Circuit being Kauai. So in the First Circuit, we have had 4 environmental court cases filed that are of a civil nature or involve agency proceedings. 3 are still pending. The first one was dismissed without prejudice by stipulation of the parties. Of the 3 cases that are pending, 2 cases involve declaratory and injunctive relief concerning violations under Chapter 343, or the Hawaii Environmental Policy Act. You know, that's the chapter that deals with environmental impact statements, environmental assessments, and the validity of those determinations. The third case that is still pending involves judicial review of an agency's decision or ruling on revocable permits. More specifically, it involves the Department of Land and Natural Resources revocable permits that were issued concerning use of state land and diversion of stream water in East Maui. In the Second Circuit, they have had a total of 3 civil and agency type proceedings. The one case, of course, is the Stop Cane Burning case, and that case settled, as I've mentioned. The other 2 cases that are pending involve requests for declaratory and injunctive relief, again regarding claim violations of Chapter 343 or HEPA, or the Environmental Policy Act. The Third Circuit has 3 civil cases pending. The environmental court judge there's 2 judges, environmental court judges on the Third Circuit in Circuit Court. That's Judge Ibarra and Judge Nakamura. 3 of the civil cases that are pending involve requests for declaratory and injunctive relief. One of those cases involves Native Hawaiians' access to Mauna Kea and implementation of an administrative rule adopted by the Board of Land and Natural Resources restricting access to Mauna Kea. The other case, the other civil case, is a request for an environmental impact statement under Chapter 343 again, regarding proposed geothermal exploration on the west side of the island of Hawaii. The third civil case that is still pending is a recently filed case, and I just don't have any information about that case. On Kauai, there has been 1 civil case, and again, that one is a matter that was just recently filed. Now, I know on the agenda, I think I was supposed to talk about just the civil cases, but I did look at some statistics regarding any criminal cases that have been filed in the environmental courts in circuit court. And again, unlike district court, we don't reach the 1,600 number, but we've had 10 criminal cases filed in all circuits statewide. Of those, First Circuit has had 1 criminal offense, or 1 criminal case. That case came and went through circuit court very quickly. There was a jury demand case from district court, and once it got to circuit court, the prosecutor's office amended the charge to a petty misdemeanor, and the case was remanded back to district court. Second Circuit, Maui does win the prize for the most criminal cases in circuit court, in environmental court. The majority of the cases in the Second Circuit involve hunting on private lands. In the Third Circuit, there have been 2 criminal cases filed, one involving an offense for hunting with a firearm without a permit and other non-environmental court-related offenses, and also camping without a permit in Ka'u Forest Reserve. In the Fifth Circuit, there was a recently filed criminal case involving a felony offense of taking a monk seal in violation of Section 195D-4.5 of the Hawaii Revised Statutes. The charge is a Class C felony that's punishable by up to 5 years in jail, 5 years in prison, and up to a $50,000 fine. The case is set for a jury trial on September 19th, 2016, before Judge Watanabe on Kauai. Other related environmental court matters, one thing I just did want to touch on briefly is Act 48. If you're not already aware, on May 10th, 2016, Governor Ige signed into law House Bill 1581, which allows for direct appeals to the Hawaii Supreme Court of final decisions and orders, or certain preliminary rulings in contested cases in proceedings arising under various chapters of the Hawaii Revised Statutes. 2 of the chapters that are mentioned in Act 48 are the State Water Code, Chapter 174C, and Conservation Districts, Chapter 183C. Both of those chapters are mentioned in 604A-2, the first jurisdictional provision slide that I went over. What happens with this act, which takes effect August 1st, 2016, is that for contested cases under Chapter 91 involving either the State Water Code or Conservation Districts, 174C or 183C, then there's no appeal to environmental court, as 604A-2 would allow. Instead, the appeals would go directly to the Hawaii Supreme Court. So again, in other words, effective August 1st, 2016, environmental court would no longer have exclusive original jurisdiction over agency appeals involving final decisions and orders, or certain preliminary rulings in contested cases involving the State Water Code and the Conservation District Code. So that is my update for the environmental court cases in circuit court. So thank you all very much for allowing me to be here.